you're welcome to Law Minstrel. I am Mwisi Mudukbe Nyim. On this episode, we'll be looking at the contract of sale of goods. For us to examine what sale of goods actually are, we'll begin by looking at an introduction. After the introduction, we'll look at the nature of a contract of sale of goods. Having done that, we'll also examine what is actually a contract of sale. Then we will proceed from there and look at the parties to a contract of sale of goods. When we are done with the parties, we will examine the subject matter of a contract of sale of goods. Then we will look at how the transfer of the property in the subject matter of a contract of sale of goods is made, and then we'll examine the price as a consideration in a contract of sale of goods. Then we'll wrap up today's episode on contract of sale of goods. Let me pause here and inquire from you if you are actually a member of our community. If you are not a member of our community by virtue of having subscribed to our channel, what are you actually waiting for? Please kindly do join our community by clicking on the subscribe button, and you automatically be subscribed to our channel. This will enable you to get all of our videos immediately as they drop, and every other opportunities that we'll be bringing on the platform for our community members exclusively, you will also be entitled to them. We also enjoin you to share our channel to others, as well as give us a thumb up or a like if you have enjoyed our episodes. And is there anything you want to say to us? Always at the comment section. Kindly drop a comment in the comment section. Thank you very much. So we will embark on our subject matter for this episode. We are looking at a contract of sale of goods, and we are beginning, as I said before, with the introduction. Actually, the law of sale of goods is very crucial in any commercial transaction, or even in commercial law. The topic or subject matter of sale of goods is very crucial, because sale actually is a focal part of commerce. Anytime many people hear commerce, you think of trade, and when you are thinking of trade, you're actually thinking of sales. That is the exchange of goods and services for a consideration, usually monetary consideration. So that's why a study on what contract of sale of goods becomes very crucial in commercial law discourse generally. So simply put, the law of sale of goods is actually the law that governs how goods may be sold, and the proprietary interest in them may be transferred from one person to the other for a consideration, usually money, legally. So whenever individuals or businesses buy or sell tangible items such as, say, food, clothing, cars, and so on, the rights and the obligations are shaped by this area of the law called sale of goods. So in the United Kingdom, for instance, the primary legislation that relates to sale of goods is actually the Sale of Goods Act of 1979, the SGA as amended. This codifies and consolidates all earlier common law principles as relating to sale of goods. Many nations in the world have modeled their own Sales of Goods Act after the British or United Kingdom SGA. Nigeria is one of such nations. Several other nations include places like the US, Canada, Malaysia, New Zealand, and even the Hong Kong Sale of Goods Ordinance is also said to have been modeled after the UK's legislation. Now, in Nigeria, for instance, the law that governs the sale of goods in Nigeria is also the SGA of 1893. This was actually a statute of general application that became operative in Nigeria. Also applicable are other rules of common law, including the law merchant or lex mercatoria. These also are applicable in Nigeria as long as they are not inconsistent with the express provisions of the SGA. The act had applied in the whole country until 1958, when it was repealed by the Sale of Goods Law. Now, that Sale of Goods Law is number 43 of 1953. Now, in the Western region, and it was actually applicable in the Western region of Nigeria. Lagos State also adopted same in 1973, and this law was, however, largely a reproduction of the act it sought or it set out to repeal. The importance of the law of sale of goods actually can never be overemphasized. It provides certainty, fairness, predictability in commerce generally. Many persons that go into commerce, you want to buy, you want to sell, you will be more at home with buying or engaging in a transaction of sale when the law as regulates that transaction is certain. If the law is certain, you can easily predict what will come out of what you are doing. And even when or if at all there is a misunderstanding or an injury proceeding from that transaction, because the laws are already clear, you will be able to predict what exactly will come out of that transaction, or you'll be able to predict what type of remedy you are going to get if the laws are clear. Okay, now that's why the importance of the law as concerning the sale of goods is crucial, and its importance can never be overemphasized. In a globalized market as we have, these rules also underpin international trade, with many jurisdictions adopting these rules in their own framework. So you have, for instance, the United Nations Convention on Contracts for the International Sale of Goods, the CISG. This governs international sale of goods. So from that legislation alone, you can see that sale of goods, it does not only happen at a domestic or a local level. Sale of goods may happen even between you and your friend. Sale of goods happens in shops that you see around your house. Sale of goods happens in even open markets that you see around. Sale of goods happen online, virtually, and sale of goods happen even internationally between nations. So sale of goods is actually very, very important. Thus, studying the law of sale of goods is not only essential for understanding domestic issues or domestic transactions that relate to sale, but they also help you in appreciating the role that this transaction, the role and the magnitude that they may attain to, even in cross-border commercial transactions or cross-border commercial dealings. Now, in studying the law as relates to the sale of goods, there are two issues that we isolate, and these issues are fundamental. So we'll be emphasizing or bifurcating the issue of sale of goods into two crucial issues. The first is the contractual aspect of sale of goods, and the second is the proprietary aspect of the sale of goods. So when you just have a sale takes place, there are two things that happen simultaneously. There is a a contractual implication of what is happening, and then there is a proprietary implication of what is happening. What do we mean by a contractual implication or a contractual aspect of the sale of goods? It essentially means that in a contract of sale of goods, when you end, a contract actually takes place. An agreement actually takes place, and this agreement must follow all the contractual rules that I hope you already know, or we are going to take out some other time to go through contracts and the rules thereof. But because this also is a contract, then it must follow all the rules of a contract. And we touched something on contract when we're doing something on hire purchase, as well as on the law of agency. Those videos are available on our channel, and you can browse through them to get to have a better understanding of what are the requirements for contract and all of that. Then simultaneously, there's another aspect of this, which is the proprietary aspect. It means that property is leaving one person's hand to another person's hand. So these two issues actually happen simultaneously when a contract of sale takes place. We'll now move from there and look at the nature of a contract of sale of goods. And in looking at the nature of a contract of sale of goods, we'll be first examining what actually is a contract of sale of goods. To begin this, there can't be a better way than to look to legislation to find what legislation says as to what a contract of sale of goods means. And we'll be looking at section 1 sub 1 of the SGA 1893. This defines a contract of sale of goods as a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. In the United Kingdom, the primary legislation relating to sale of goods, like we said before, is the SGA 1979 as amended, which codifies and consolidates earlier common law principles. This act defines a contract of sale of goods as a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration known as the price. You can see from these two definitions, from the UK SGA as well as the Nigerian SGA, you can see that their definitions are similar. They are therefore in pari materia. So, but a close examination of these definitions will bring 4 critical issues, and these 4 critical issues we are going to take a look at them. The first is that a contract of sale is a contract between the buyer and the seller. I am isolating these issues directly from the definitions as given by the 2 SGAs that we looked at. You remember that we said that they said it's a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. So the first thing we are looking at there is that a contract of sale is a contract between who and who? The buyer and the seller. So it means that the parties to a contract of sale of goods are the buyer and a seller. These two are critical for a contract of sale of goods to be said to exist. The second issue that these definitions bring to the fore is that a contract of sale is one whose subject matter is goods. Goods must be the subject matter of a contract of sale of goods. So the subject matter of sale of goods is goods. Simple. The third thing that this definition brings to the fore is that a contract of sale is one in which the property in the goods is to be transferred from the seller to the buyer. When a buyer pays the consideration, which is usually money, he expects, there is an expectation he has in mind, and the expectation he has in mind is that the property in the goods will be transferred from the seller to him. If it were not so, he will not part with his money. It will make no sense at all for him to actually part with his money. And finally, a contract of sale is one in which the transfer of the property in the goods is done for money consideration. The seller also has something he wants to gain out of transferring his property in the goods to the other person, and the gain he expects out of a contract of sale is the money consideration. So in any contract of sale of goods, each of the parties has a gain he sets out to obtain. The buyer has his gain in sight as the proprietary interest in the goods, otherwise known as the property in the goods, while the seller's interest or gain that he sets out to get is the money consideration. So at the end of a contract of sale of goods, each party wins. Is usually a win-win situation. We'll now look at the parties to a contract of sale of goods in detail now. A contract of sale of goods presupposes two parties, which we had looked at before, a buyer and a seller. You see the Sale of Goods Act, as we already cited, which is particularly section 1 sub 1 of the Sale of Goods Act. The UK case of Helby versus Matthews is also a good authority to substantiate the fact that the parties to a sale of goods contract are a buyer and a seller. In the US, see the Uniform Commercial Code, UCC Article 2, particularly on section 2 to 103. Now, ordinarily, the same person cannot be both the buyer and the seller. However, there are unique situations where this could occur. So, for example, a part owner may sell his share to another part owner. That's a unique situation whereby somebody will be both a buyer and a seller. Let me just pause and try to run that again so that you get what we're saying. We're saying that usually a buyer cannot at the same time be a seller. That's the normal thing. But there are unique situations whereby it will appear as if someone is both the buyer and the seller. Although when you critically look at it, you also see that he's not particularly both a buyer and a seller. For instance, if both of us paid, we're supposed to get this, we needed a pair of glasses and we couldn't afford to buy one by ourselves. Neither of us could afford to pay the full price for the purchase of a pair of glasses. Assuming the money required was, say, $10, and then you brought $5, I brought $5, we collectively bought this pair of glasses. Means that both of us own this glass. You own a 50% proprietary interest in these glasses, and I own a 50% interest in the glasses. In the event that you are maybe relocating to another city and we cannot both make use of these glasses, you may decide to sell your own 50% interest in these glasses back to me. So it will appear as if you are selling part of these glasses to me, and that you are both an owner and you are both an owner and at the same time a seller. And for me, I who is buying from you, it will appear as if I am both an owner and a buyer at the same time. But when you critically look at it, it is not the entire eyeglasses that I'm buying. Do you remember? I'm only buying the 50% interest in these glasses that does not belong to me. That's what I am trying to pass across to you. So the buyer, whether an outsider or another co-owner, only acquires the part owner's share, not the entirety of the goods. And you see the authority of Afolabi versus Polymera Industries Limited. You see the citation given to you on the screen. You also see the US case of Port City Construction Company versus Henderson. The citation will also be supplied on the screen. And finally, in India, you can have a similar situation as seen in the case of Mohori BB versus Damodas Gose. So those are the cases that justify what I've tried to set up. So the parties must also have the legal capacity to contract. If they do not have the legal capacity to contract, they cannot pass a proper title, which means that they must not be minors, they must not be mentally incapacitated, they or otherwise disqualified by the law as concerning contract. So you see the authority of Afolabi versus Polymera Industries Limited again, and also the UK case of Roland versus Dival, and in Canada you see the case of Bevo Farms Limited versus VegGrow Incorporated. Now, contracts entered into by those lacking capacity may be void. They may either be void or simply voidable, as general contract law dictates. See the authority of Nash versus Inman concerning a minor's liability for necessaries. Now, we'll now move to the subject matter of the law of contract. Move to the subject matter of contract of sale of goods. What's usually we already said when we were isolating the issues from that definition that the subject matter of a contract of sale of goods is what? Is goods. So it is clear from the definitions given that goods are the subject matter of a sale of goods. Now, however, not all goods are actually the subject matter of a contract of sale of goods. So now what we have said generally that goods are the subject matter of a contract of sale of goods. So the next question is that is it all goods that are a subject matter of a contract of sale of goods? If it's not all goods that are a subject matter of a contract of sale of goods, what type of goods pass as a subject matter of sale of goods? So for this we'll be looking at the definition of goods as defined by the Nigerian SGA, and this will be under section 62 sub 1 of the Nigerian SGA. All personal charters other than things in action and money, and includes embalments, industrial growing crops, and things attached to and forming part of the land which are agreed to be severed before sale or under the contract of sale. Yeah. Goods include every kind of, from this we see that goods include every kind of movable property, including stocks and shares, growing plants, and industrially severed items such as timber. So goods refer to all forms of movable property, excluding money. You know, ordinary money is a good, isn't it? But by this definition under section 62 sub 1 of the SGA, money is not contemplated as a subject matter for a contract of sale of goods, even though money in itself could be a good. So jurisdictions across common law traditions have adopted similar statutory frameworks while clarifying the scope through case law. So I will refer you to Sale of Goods Act 1979 of the UK. This you will find it under section 61 sub 1 of that act, the Uniform Commercial Code, as well as the Sale of Goods Act 1930 of India, and for that you find it under section 2 sub 7. Now the list of what goods are is not exhaustive, but it clearly excludes real property and intangible assets. So while the act may not go into listing every conceivable item that is a good, it mentions things that are excluded. So once any item falls under a general class that is isolated as not forming part of the goods as contemplated under the act, then that kind of thing will not amount to a good as relates to the subject matter of a sale of goods. So goods are further classified in the Nigerian SGA. You see section 5 sub 1. In the UK, you also see it under section 5 sub 1. And the classification is important in that it informs when a property in the good passes and the enforceability of the contract as well. So we will now look at what this classification of goods has done under the Act. Under the Act, when you look under the Act, you find, particularly under section 5 sub 1, like I said, you find that goods are classified into existing goods, into future goods, and into contingent goods. And this classification is not for classification's sake, is not for cosmetic sake. It serves a purpose, and it's important for you to understand this classification because it will help you to know when the property in the good passes. That is, when the property in the good, in this type of good, will move from the seller to the buyer. It will also help you to know the enforceability in that peculiar contractual situation. So we'll begin by looking at existing goods. What are existing goods? Existing goods, just from the word existing goods, I think the simplest way to define existing goods is to simply say that existing goods are goods that are what? That are existing. So these are goods which are owned or possessed by the seller at the time of the contract. So when you define existing goods simply as goods that are existing, you may wish to know that at what time are these goods existing? They are actually existing and are in existence at the time of the contract. So existing goods are goods that the owner owns and possesses them at the time of the making of the contract of sale in issue. So in other words, an existing good is one in which the owner is owned by the seller at the time of the contract of sale. They may be specific or they may be unascertained. In the case of the latter, it simply implies that the goods contracted for are known and agreed upon at the time of entering the contract for sale, whereas in the former, where they are unascertained, they are not. So in the Sale of Goods Act of 1893, specifically section 5 sub 1, existing goods are defined as the goods which form the subject of a contract of sale, may be either existing goods owned or possessed by the seller, or goods to be manufactured or acquired by him after the making of the contract. And you will also see this on the authority of the Afolabi case earlier cited. You also see this distinction between existing goods and future goods done very properly in the case of Henningsen versus Bloomfield Motors Incorporated, citation supplied. We'll now look at future goods. Future goods are like the opposite of existing goods. They are goods in the future. They are not present now. So they are not present at the time of the making of that contract. So these are goods which the seller agrees to manufacture or to acquire after the contract is made. They will become in existence after the making of the contract, whereas existing goods are goods that are already in existence at the point of making of the contract. So in other words, they are goods not in existence at the time of entering into the contract, or in existence but not owned or in possession of the seller at the time of entering into the contract. Thus, they are goods to be manufactured or produced or acquired by the seller after the making of the contract. Under the Nigerian SGA and the UK SGA, it is clear that future goods cannot be the subject of an immediate sale, although they can be the subject of an agreement to sell. Because they are not yet in existence, they cannot be a subject matter of an immediate sale. Why can they not be a subject matter of an immediate sale? It's because when you do this, at the time that you do that sale, the property in the goods may not immediately pass to the owner, and the owner will not be able to take possession of the goods immediately because the goods themselves are not in existence. They will only come into existence at a future date. So in the case of reweight, the court held that the contract relating to unascertain future goods creates only contractual rights until appropriation. This is actually in pari material with the US position as well, where the UCC provides that goods which are not both existing and identified are future goods. A purported present sale of future goods or of any interest therein operates as a contract to sell. This is similar to the UK situation as well as the Nigerian situation, like we have also said. By virtue of this, therefore, a buyer of future goods receives only contractual rights but not ownership until the goods exist and are identified. Finally, we will now look at contingent goods. Contingent goods. These are goods which depend on uncertain events. In other words, they are goods whose existence is contingent upon the happening of something. That is why their name is actually contingent goods. So a good is termed a contingent good where the supply of same is dependent upon the happening or the non-happening of an event or a certain condition or a state of things. Where the contingency for the supply is met and the seller defaults, he becomes liable. But where the contingency fails and the seller defaults, then he cannot be liable. In other words, contingent goods are goods whose acquisition by the seller only depends on the happening or the non-happening of a future event that is also uncertain. So in the Nigeria and UK sale of goods, you will find something on this under section 6 sub 2, and it provides thus where a contract of sale, whereby a contract of sale, the seller purports to effect a present sale of future goods. The contract operates as an agreement to sell. Where the acquisition of goods depends upon a contingency which may or may not happen, the goods are contingent. So again, in the case of Anderton and Co. and Hardwick's contract, the court re-echoes the principle that contingent goods are valid subject matter but remain only an agreement to sell. Sorry. So with this now, we'll go to the transfer of the property in the goods in a sale of good contract. Actually, the transfer of property or the transfer of ownership in goods is one of the most fundamental issues in the law of sale of goods as well as in any other contract of sale actually. Because if the goods or if the property or the ownership in the good is not going to transfer, it's not going to move from the seller to the buyer, then why should the buyer use his hard-earned money to go and purport to buy something when the property will not move to him? Don't you know that a man's treasure is where his heart is? A man's heart is where his treasure is, and money is a treasure. So people's hearts are usually where their money is. Why will he take his hard-earned money, or why will even you take your hard-earned money to say you are entering into a contract of sale when the property will not pass to you, having departed or parted with your own hard-earned money? So it not only determines who bears the risk, who has title, and the enforceability of remedies against third parties, but it is at the heart of the reason the buyer enters into such a contract ab initio. The main purpose of any contract of sale is to transfer property or ownership in the goods from one party, which is called the seller, to the party which is called the buyer. The property in the goods could be general or they could be special, the former connoting absolute ownership and the latter limited rights, as in the case of a lessor and a lessee. So that the property in the goods should pass to the buyer is captured under section 17 of the Nigerian Sale of Goods, and that provision provides inter alia, where there is a contract for the sale of specific or ascertained goods, the property is transferred to the buyer at such times as the parties intend it to be transferred. From this section 17 of the Nigerian SGA, it can be deduced that parties ought to have a time at which point the property in the goods may pass from the buyer to from the seller to the buyer. So the Nigerian SGA goes further to make provisions covering circumstances where that intention is unclear. It means that there are situations where the parties, that is the buyer and the seller, clearly stipulated when the property in the goods should pass from the seller to the buyer. But there are circumstances in which they don't clearly stipulate. They have that intention that the property should pass from the seller to the buyer, but they have not clearly designated such a time when the property is going to pass. And when that is not clearly done, the SGA makes provisions that cover such uncertainty. So when parties make it unclear, you have to rely on the law to know when the property actually passed, or at least to know when the law deemed the property to have actually passed from the seller to the buyer. And you will see this under sections 18 to 20. These rules, I'll just capture them under rules, and I'll be looking at them. They are rules 1 to 5. The first rule, rule 1, is unconditional contract for specific goods in a deliverable state. When this time that the property will pass is unclear in a contract relating to in a contract that is an unconditional contract for specific goods in a deliverable state, then the property passes when the contract is made. Immediately the contract is made, the property passes from the seller to the buyer. And see this on the authority of Carlos Fidaspie versus Charles Twig. You will see the case and the citation supplied. So rule 2, where seller must do something to put goods in a deliverable state, where in that contract the goods are not yet in a deliverable state and the seller is supposed to do something to make the goods in a deliverable state, and then the time for the transfer of the property in the goods is not specified in that contract, then the property passes when that condition is fulfilled. Immediately that condition to make the goods in a deliverable state is fulfilled, the property without any more passes from the seller to the buyer. Rule 3. This rule relates to where a seller must weigh, measure, or test goods. Where the goods that are the subject matter of a contract of sale are such that the seller must measure, must weigh, or must test those goods. In that type of contract, if the contracting parties do not clearly state when the goods will pass to the buyer, then the property in those goods will pass when act done and buyer notified. That is when any of those acts required are done and the buyer is notified. For instance, where it is weighing that the seller has to weigh, when he weighs and he finishes weighing it and notifies the buyer, then the property passes. If it has to be measurement and he measures and notifies the buyer, then the property passes. Where it has to be testing and he tests and he notifies the buyer that he has tested and everything is okay, then the property does what? It passes to the buyer. And you see this on the authority of the case of Waite versus Baker. Rule 4 now has to do with goods delivered on approval or sale or return. So in this situation, the property passes when buyer signifies acceptance or retains goods beyond agreed or reasonable time. And you see this on the authority of Kilcam versus Attenborough. Then rule 5, which is the final rule for uncertain goods. When the subject matter of that contract is an uncertain goods, then the property passes when the goods are ascertained. And you see this on the authority of the case of Waite. With this now, we'll be moving on to the price or consideration in a contract of sale of goods. We have already mentioned, albeit in passing, that the consideration in a contract of sale of goods is what? Money, or the price. The price of the goods when paid is the consideration. So the consideration in a contract of sale must be money. See the authority of section 1(1) of the Nigerian Sale of Goods and also the UK Sale of Goods Act. So unlike ordinary contracts where considerations may take various forms, in a sale of goods contract, the consideration must be monetary. The statutory requirement that consideration in a contract of sale must be monetary ensures clarity and distinguishes a sale from other similar transactions, like say a barter or an exchange of goods. So a contract where goods are exchanged for other goods is a barter, not a sale. So you hear it said that it's a trade by barter, So however, a part payment in goods in money may still constitute a valid sale. So where a party pays part in goods and pays part in money may also constitute a valid sale. So the price may be fixed by the contract, left to be determined by a manner agreed upon, or determined by the course of dealings between the parties. So because sometimes when you go, the parties may argue about the price and then arrive at what is agreeable between both parties. So if the price is not determined in any of these ways, the buyer must pay a reasonable price, which is a question of fact. So sometimes you go to buy something from someone, maybe the person has a type of relationship with you. The person would be like, please, it's okay, it's you, it's coming from you, so pay me anything you give me, I will take, don't worry. So in that circumstance, the onus now lies on you, who is the buyer now, or at the benevolence of the seller. The onus now shifts on you to pay something that is reasonable. It's alright. So sometimes if you don't pay something that is reasonable, like this pair of glasses now, assuming I was selling and then somebody comes to me, ordinarily maybe in a regular shop the glasses should go at about $10, and then you came to me, and because you were probably one of my bridesmaids when I was getting my, I said, oh no, no, I can't call a price for someone. Like, you just give me anything will do, and then you decided that you would give me $1. And sometimes somebody who has a very large heart may still collect the $1 and smile and be okay and be genuinely fine, but you will find some sellers that they will collect that money because they had already tied themselves that, oh, anything you give me, I'll collect. They will collect, but you see that their countenance will fall. It means that it goes way below what they feel is reasonable that you should have given them. Thank you. So if the price is not determined by the seller, then it's now is left to the reasonability of the buyer, of course. And you see this on the authority of Foley versus Classic Coaches Limited. The Court of Appeal upheld an agreement where the price was left to be agreed upon by the parties, demonstrating that courts may enforce open price terms provided there is a mechanism to determine reasonableness thereof. So without a price or an ascertainable method of fixing it, no enforceable contract of sale will exist. So note that the UN Convention on Contracts for the International Sale of Goods 1980 allows contracts without express price, provided goods are delivered at a price generally charged under comparable circumstances. You will see this under Article 55 of the CISG. It's okay. So with that, we'll move to the meaning and nature of price. What is the meaning and what is the nature of the price? So price may be defined as the money consideration that is paid for the transfer of the property in goods from the seller to the buyer. It distinguishes sale of goods from barter and exchange, like we earlier said, where goods are traded for goods. So one of the first issues is that payment of the price may be entirely in money, or it may be partly money and partly goods, like we said before. See this on the authority of Akinsonya versus UBA Limited, citation supplied. So we'll now look at the modes of fixing the price. So Section 8 of the Nigerian Sale of Goods Act recognizes three main ways in which price, which is the consideration in a contract of sale, may be determined. The first method it recognizes is by contract. The second is by an agreed method, and then the third is by cost of dealing or reasonableness. So in the first, which is by contract, where the parties expressly stipulate the price, then you say that this is by contract. So e.g., 5,000 naira or $5,000 or £5,000 for a bag of rice or for a handbag. That's by contract. So by an agreed method, that's the second way of determining the price, where the contract provides a mechanism for determining price, e.g., market price on a given date, or by valuation from a third party. So then the third is by cost of dealing or reasonableness. Now where prices, this happens where price is not fixed, and you see this under section 8 sub 2 of the SGA. Implies a term that the buyer will pay a reasonable price, which is a question of fact. See this on the authority of May and Butcher versus R. Thank you. With this, now we'll move and examine price determination by third parties. How are prices determined by third parties? Now, sometimes contracts allow price to be set by a third party, like an arbitrator or even a valuer. So where the valuer fails to act, however, the contract may be void unless goods have already been delivered and accepted, in which case the buyer must pay a reasonable price according to section 8 sub 2 of SOGA. In May Butcher versus R, the court held that an agreement to agree on a price in the future is not enforceable unless a mechanism is clearly set. We'll now look at the actual payment of price. The actual payment of price. What are the rules that govern how price should be paid? These include the time of payment. So unless otherwise agreed, payment and delivery are concurrent conditions. 2 is credit sales. Parties may agree that payment be deferred. The third is in relation to installments. Now, price may be payable in installment depending on contract terms, which is of course between the parties. And then the final issue is the tender of price. If the buyer tenders the exact price and seller refuses, buyer may be discharged from liability. We'll now look at remedies that are available for non-payment of price. Now, where the buyer fails to pay the price, what are the remedies that are available to the seller? We'll take a look at the authority of SOGA, particularly sections 38 to 48, and you will see that the remedies available are: 1, a lien. What do we mean by a lien? A lien means that a lien means a right of the buyer to retain the goods in his possessions until the price is paid. The right of the seller to retain the goods in his possession until the price is paid. Also, the second remedy that is available to a seller when the price is not paid is stoppage in transitu. Stoppage in transitu means stoppage in transit. So if a buyer becomes insolvent and he's unable to pay the price, and assuming as at the time he was on, it came to the knowledge of the buyer that he has become it came to the knowledge of the seller that the buyer has become insolvent and he's unable to pay the price for the goods. The goods were in transit on delivery to the buyer. Then the seller has a right to stop the goods in transit, thereby stopping the delivery, and then the goods will be brought back to him. But this right can only be operational when the goods have not yet been delivered. The goods are merely in transit. If the goods have already been delivered and the purported buyer has already taken delivery, then you cannot say that you have stopped the goods in transit. The goods must first of all be in transit for you to be able to exercise a right of stoppage in transitu. So another remedy that is available to a seller is the remedy of resale. Means that the buyer was unable to pay the price he's supposed to pay. You have a right to resell your goods to another person and probably make him a refund where he had maybe made an installment or something. The fourth remedy that is available to the buyer is action for price. Action for price. So if property in goods has passed to the buyer, the seller may sue him for the price he ought to have paid, which he has not paid. So you see this case of Coley versus overseas exporters. And 5, damages for non-acceptance. If property has not passed, seller may claim damages instead. It's all right. So with that, we have come to the end of our study today, of this episode today. And for me to do a clean wrap up on what we have done so far, I'll just do a run through of what we were able to take today on the sale of goods. We did look at an introduction to the topic. Then we looked at the nature of the contract of sale, and then we examined what is a contract of sale, and then we looked at the parties adhered to a contract of sale of goods, and then we looked at the subject matter of a contract of sale of goods. Then we looked at the time that the property in the goods transfer from the seller to the buyer, and then we looked at the price, which is the consideration in a contract of sale of goods. With that, we have come to the end of this episode. Thank you so much for staying all the while with us. I remain Mwesi Modupe Nyim. Till next time on this channel, please do subscribe to the channel. Please give us a like and a share to persons within your own sphere of influence as well, and then drop a comment in the comment section. Thank you very much. Bye.